Okay, wait a second. This goes to a case that's not on calendar today. Good morning. This is case D 516583, set today for calendar call. Counsel, kindly your appearances for the record.
Good morning, Your Honor. Don Throne, bar number 6145, on behalf of the defendant is present.
Good morning and welcome.
Robert Glennon, bar number 2143 for plaintiff.
Good morning and welcome. I don't have a pretrial memo from the plaintiff. Did you file one that I'm not aware of yet, Robert?
No, Your Honor, I was hoping to finish it last night. I am able to meet with my client today and submit it today.
Okay, so do you think you can have it filed by tomorrow or Monday?
Today by 5.
Okay.
Going out on a limb. I would like to say...
I'll just say by tomorrow, just in case. I don't
That's
want
fair.
Dawn or Michelle to come in and tell me that it wasn't in by 5. Let's strike it, because I have to decide these things on the merit. So let's say by 10 tomorrow morning.
Fair. Thank you.
I do want to, just housekeeping-wise, talk about the Discovery Commissioner hearing that's set afterwards. And I don't know if you want to know us here, if you want to sit for me to hear it today, because it seems really straightforward. It seems it's about just the request for production of documents. Have you been served with that, Robert? You look like you don't know about it.
I would say I was given that by email. I would say I'm not officially served with it. I've been very accommodated in responding to discovery that's been served by email under our local rules, but I don't think that there's ever been a formal waiver of formal service done.
You don't think you've agreed to email service?
Right.
Well,
That's the problem is he was ROC. It was ROC'd on his office.
right, I have an ROC that it was picked up on February 9th. By the person who signed it was,
Then there's no need to talk about
well,
email
I'm wondering, I don't have any response, and either they have to file an OST and be asking for more fees to get in front of the commissioner ahead of time, because we're set for trial April 15th, and it's on the Discovery Commissioner's calendar April 29th, but I could rule on it today. Really all it is asking is, hey, we've asked for, we've given time for these requests for production of documents. I looked through all of them. They're all pretty basic things having to do with relevant and material issues with custody or financial issues regarding taking care of kids. They want their fees and they want the documents, or really the whole thing in a nutshell. So I don't know if you have a right to have it heard before the commissioner. You don't have to stipulate to have it hear it today. If that's going to happen, I have to ask them to do an OST so they can get in front of him before the 15th.
Or you move the 15th.
Or move the 15th.
I mean, my opinion is there's no reason to have an evidentiary hearing in this case. So there's no reason for him to file pre-TM late now. It hasn't done anything. You already made a final custody order in this case. The real question is, he wants unsupervised visitation.
Right. It's not about custody. It's about what visitation will he have.
Right.
And
you gave that to him in January, and my client's okay with that continuing.
Well, do you guys want to talk to each other and see if you can just agree and wrap it up today and take all this stuff off calendar? I just got the options. Did Dad complete it all? Yeah, 12 to 12 weeks. Good job. And you're doing the DV counseling. How far are you into the 28 weeks, Dad?
I think I have like 13, 14 left.
No. Your report that you got today that we just picked up says...
I didn't read it yet.
3 out of 28 was all he has done as of today.
Is that true, Dad?
No.
How many have you done?
I have like 6 or 7.
You've done 6 or 7?
Yeah, I have all the case
But there's
studies.
28 total.
Yes.
So you still have at least 20 to go?
Yes.
Okay, well, I ordered it a long time ago. Why didn't you start it earlier?
Being caught up working, getting everything else done, getting situated with work. I just got another job, so I quit my other job.
He quit his job 2 days after your last hearing, Your Honor. And he's been working back at Wendy's. He's not paying child support. He didn't pay the drug testing you ordered and pay within...
Do you want me to add willfully underemployed for purposes of avoiding support? It's a clear and convincing burden, though.
No, my client doesn't want to spend the attorney's fees enforcing that. The DA will catch up with him eventually. They're calculating his arrears and his interest and penalties on that. His child support's already set there. Just leave that alone as my client's preference. But she doesn't want to pay for an evidentiary hearing when we don't need one. He hasn't even done the things you ordered. He started this DB counseling late. You ordered him to do it back last year. He didn't do it.
I ordered it, I think, last summer, didn't I?
Right, so if we keep the visitation the same way it is as of the January 14th order, enter a final custody order.
Just
He's
put
not
the-
complying with the no contact with his family either. He lives with them. So he is taking the daughter back to his family's house. He is exposing them to the family like you told him twice in the minutes not to on January 14th. It's just no discovery, no PTM. He just doesn't care.
She's alleging that he's using a lot of alcohol or excessive alcohol at this point. Does she have evidence of that? Like he's with the child when he's inebriated or impaired?
That was prior. We don't have any evidence that says January 14th. He's exercised the visitation. There's not been any contact because he picks up and drops off at daycare. It is working out.
So what do you think?
Well, one, regarding the payment for the drug test, I have a letter here with allegedly a certified check in it, dated March 3rd, that went to Brandy at 9228 Lost, Shandy Court. It was returned. I'd love to do that today, have it sent, have it given
Could you hand
to
that to Dawn, and her client will verify
Maybe we can take care
that
of
it's
that
there.
part.
It looks like that was a mishap.
And second, the issues that we would see is if we have a ruling on physical custody, we're not prepared to go to a hearing to change that at the present. We do think that there's an issue regarding the stay away for grandma and grandpa. We think that's unreasonable, but there is not anything regarding custody that we can do on the 15th of April.
So you want to vacate that evidentiary hearing?
I don't think it can solve anything, so yes.
Okay, and then Dawn, do you want the Discovery Commissioner motion off calendar as well?
Yes, John. I guess the issue becomes the attorney's fees. We did discuss. He asked for an evidentiary hearing on changing to unsupervised visitation. You gave that to him. We did discovery. We even subpoenaed records from the employer he put on there as only FDF that I've seen filed. We get it back saying he quit that job 2 days after your last hearing. He hasn't updated that, saying where he's working, so I could subpoena those records. It's just complete non-compliance. There isn't a question of attorney's fees here. That's what I'm saying.
Your Honor, I'm still. I know I'm not in Las Vegas. I'm in the middle of the state, but it is the United States. I don't see a discovery letter talking about, hey, you're late. I didn't have it down.
It's attached to the motion. It's
Where did it go?
The EDCR 2.34 and 511 letter was mailed March 21 to your office.
And we mailed him before.
If you're still at Fort Apache's number 100.
Yes, I am at Fort Apache.
That's attached to the motion. I don't know if you want to look at this. All I have tabs on is the two things, the letter and the ROC, if you want to look at my copy.
We faxed.
They're asking for fees for having to do this. They technically would be allowed fees if he hasn't done the request for production. What I could do is just say, hey, do a memo of costs and fees with a blank order, serve it on them, courtesy copy me. You can have 2 weeks or 10 judicial days to file an objection to whatever they're asking for and all the reasons why they shouldn't get this or that. And then they have no response. So it's just one pleading, one blank order for whatever is appropriate, and then the current orders stand, correct?
I think we should prepare. There wasn't an order prepared from your January 14th hearing. I believe Mr. Glenn was supposed to prepare that according to the minutes and didn't get done.
That's correct. I'm still
so-
waiting for the minutes, and I'm not putting blame anywhere.
Oh, we didn't get them in. I've had a...
The minutes are on Odyssey. You can go and click on it. Oh, they come up.
I looked, and I couldn't click on it. Maybe
I have it.
maybe your computer's
We've been
magic.
having a
I have
couple
magic, yes.
issues with them, but I haven't checked on that.
The problem is that we tried to comply with EDCR 2.34 and call Mr. Glennon. His phone's not in service. The number he has on the board.
Oh yeah, I was going to ask you, because my law clerk tried to call and leave a message, but it doesn't allow to leave a voicemail. Do you have a different number? I know you just moved, right? You moved to this place, or you didn't move, or what happened?
Well, there's certain disputes with the phone company regarding that number, but I'm available at my day job, and I gave that to the law clerk. He was able to call me yesterday.
Okay, good. So you talked to him?
Yes.
Okay, good.
We sent a letter via email to the email address he has on file in the book and with the bar, and didn't get any bounce back on that letter regarding the discovery, because you're supposed to try to have a conversation with the opposing counsel.
If you want to do the order, the order that Bob was going to do, and do your memo costs and fees, like make the temporary order permanent, and separate Brunzell Miller Wolfong memo with your billing attachment, with redacting anything privileged, and the separate order for fees, and then serve it proof of service on Bob. If he doesn't want email, then it needs to be mailed, or ROC obviously, and then he can object within 2 weeks or 10 judicial days, 10 working days.
And I understand, Your Honor's
I'm trying to find out how to end the case and make it fair.
decision regarding the discovery, but we didn't request this evidentiary hearing at the last hearing. I believe the minutes will and tape will show that we didn't ask for it, that the defendant did.
Well, that's my job to set one when you guys don't have an agreement. If there are tribal issues, and he wanted unsupervised, so I gave him some pathways to success. You know what I mean? And it's not done. So they're saying, why do we need one? Why do we have to pay to come to court when the things that I ordered for him to do, he's done some, not all. I'm glad you're clean. You must feel better.
Yeah.
I hope you do.
I was told that I had a year to do the anger management program, though. I wasn't told that it was needed to be done immediately. That's even in the minutes. He told me I had a year.
Does it say that in the minutes?
Yes.
That doesn't say that.
I don't recall saying
It says it
that.
twice. Dad shall complete the domestic violence course. Dad shall complete the domestic
Can you
violence
print the order and see if I gave him extra time to do it? It's a left side. It'll be a left side filed, and it's from back in, I believe, August 2015. The options DV thing. I mean, normally I don't tell people something like that, but I can't remember, so I want to look at the order first. Normally I just say, look, I want you to do these things based on the facts, and hopefully those remedial outsources, interventions, will change the dynamics, change the way people interact with each other, change the way parenting happens. Basically,
Yes.
yeah, that's it. Thanks.
And, Your Honor, I have the minutes today right now. Would Your Honor like to order me to complete the actual order in the very near future then?
Do you want to do it, or do you want me to have them do it?
I'll just do
Good,
a
I just
final
have it.
order. It doesn't need to.
Because otherwise it's going to have to be made into a final one anyway.
True.
So
I'm
just
good
let
with
that go, and I will just say the minutes to suffice for that prior order, and Don will do a final order making the temporary order permanent. And then I don't see that it says anywhere on here a year in the minutes or in this order. So, I mean, he might have got confused, but I don't know how. It's domestic violence 6 months, domestic violence 1 year. I don't know if he thinks that means he has a year to do the 6 months. I have no idea. That's not the way I would read it, but that's the only thing that refers to it.
You ordered that in August, right?
Yeah,
And then-
August.
And then you ordered again on January 14th.
I reiterated my order, I think, because it hadn't been done.
The
Okay.
only other thing, Your Honor, that needs to be addressed to how her in order is you extended the TPO to April 15th
Which was the date of the trial.
trial. So, and
What was the
where
day
in
it was
TPO
issued?
rule, you cannot extend it
Past a
any
year.
further, but we would like a permanent no contact order between that. He doesn't need to go to her house. He doesn't need to go to her work or anybody on his behalf, and it can be mutual. They can, just like they've been emailing regarding their daughter, and that works out.
I'm glad that the daycare exchange is eliminating opportunity for conflict.
Yeah.
And if you guys are willing to stipulate to a mutual no contact order that you just can keep doing the exchanges at the daycare, doing all your co-parenting by email, absent emergency. Obviously, if the child goes to the hospital for some reason and you have to both be in the same room, I would hope to God that you could be cordial with each other around your child medical problems that involve an emergency situation. But other than that, that would like be an exception to the rule, where you have an emergency.
Now, I do not represent Grandpa, but he wishes to address the court regarding his no contact. He's not seeing his grandchild.
He has to file something. It would violate the Constitution ability to give notice and opportunity to be heard. He actually would probably have to file a separate case, a petition, under 125C 050.
And he has no standing to do that since he's not related to this child at all.
Well, I don't know those answers. So that would be the avenue if he meets those criteria. I can't just let him talk out of turn in the middle of a hearing. That would be basically taking evidence without any notice, complete surprise.
Right, but the worry I have about no notice is if our permanent order says stay away from him, then it's in the record without him having a chance to respond.
Well, he doesn't have rights. That would be Dad's right to speak to that. Does Dad want to speak to that?
Yeah, I want more than Wednesdays and Fridays. I want 50-50 custody.
That's not going to happen in this case. That's not going to happen in this case.
Okay.
So does he understand what you're agreeing to today? I mean, it sounds like he doesn't even understand that.
We have a courts and indulgence. We have a chance to go to the hearing and ask for 50-50.
That's what I want.
If we don't, then we agree to primary. So you don't agree to primary.
My primary.
That she gets more than 50%. The amount of visits we get to increase over time, but
So I stick with Wednesdays and Fridays.
no. Right now, you're sticking to Wednesdays, Fridays. We can ask for more time without asking for 50-50. If you want 50-50, this is the day that we have to ask for.
That's what I want.
All right. Yes, Your Honor, I apologize. I hadn't talked to my client on this particular issue. He wishes the hearing to go forward regarding 50-50 custody.
He doesn't have a basis for that. He hasn't even done the DV. I'm making a finding there's no cause for an evidentiary hearing on custody or on visitation.
And there's no motion pending. There's a due process issue on that.
Yeah, he doesn't have a motion for 50-50 custody on calendar. It was about having unsupervised visitation, which he has.
Yeah.
Right, I think the original motion was for shared custody.
There's a final custody order entered by the court on October 27th, closing this case.
That's correct.
The court did it itself because nobody submitted the order. There's no basis for an evidentiary hearing. Dad was limited to supervised visitation until he completed his options, and he couldn't do that. That's a
And now you got a trial in 2 weeks, but he hasn't done it. So why do we go to trial when he hasn't done it? It's a condition precedent, and he hasn't done it. And he's had months and months to do that. Is there any benefit to you guys talking in the hall about anything? Or do you, I really don't see anything that I can do differently other than make a finding that there is no cause for an evidentiary hearing because the domestic violence, Dad did come clean, 12 patches. He's clean. So he did complete that. But the domestic violence, which there's just, their pre-trial memo is replete with domestic violence examples. I don't know if you've read that. But it's replete with examples. And still, we've never had a trial in this case, so all that DV is a grist for the mill, even if it came back because of Castle versus Simmons. But if they prove what's in that pretrial memo, and he has not completed his DV, I'm more apt to give supervised again. If he's going to have a single episode of domestic violence, verbal, physical, any of that. I'd be more inclined to go back to supervised because of the way that he handles things. However, if he gets that done and maintains, with the no contact, I think that helps a lot. With co-parenting by email, that helps a lot. They're not coming into contact with each other, so they're not having an opportunity for conflict. But he's not a candidate for joint physical. He's not. He's just not. He's got a long history of substance abuse, a ton. Did you read their pre-trial memo? Because it's just probably has.
Yeah, that's why we thought we'd be going all day. Because we thought we'd have to disprove all those
why
things.
do I need to go to trial when I've asked him to do a couple things and he's only done one?
That's understandable, Your Honor. Your Honor's going to make that ruling.
And you granted the motion he asked for. You granted.
I gave him unsupervised.
Done, unsupervised, appropriate. Go from there. My client's not trying to change it.
He filed his motion November 19th, and asked for the court to award the right to reasonable visitation to plaintiff unsupervised. That's the motion right here. Do you want it?
No, I believe you.
That's the November motion. So nothing else is before me, and he's already got his relief in that regard. I don't really think that there's anything left to say. I mean, I'm going to ask Dawn's firm to do the final order, absolve Mr. Glennon from having to memorialize the temporary order because we're going to make a permanent order. So the minutes will suffice for that order from the hearing, and then any attorney's fees awarded will be handled through the process of defendant providing a Brenzel Miller Wolfong memo, courtesy copying the court on that, and a blank order proving service on plaintiff, who will have 10 judicial days, 2 weeks from service of that document to file an objection and courtesy copy the department. Because if I don't have you on my calendar, I need a courtesy copy to trigger, what I'm trying to do. So if you give me that stuff, and then the Michelle or Dawn and Michelle have no right to respond to that, your objection, and I'll make the order. And then Dad, he has no reason to come back in. I'm telling him right now this is not a joint physical case. But, with regard to the child support issues, do you want me to ask where he's working now?
I don't even care, Your Honor. That DA's office will enforce that. She can't afford for me at $350 an hour to.
So DAFS will continue to enforce and collect the child support until a subsequent order.
Yeah, he's been paying, but he pays dribs and drabs, and I don't know why they're not garnishing his wages. Probably because he hasn't kept them informed. But he says he's working back at Wendy's again.
I never said that.
All right.
Yes, ask him where he's working, and I'll let the DA's office know to garnish that.
Where are you working, Dad?
I work at Peak Mart Car Wash. I work at a
What
car
is it
wash.
called? Car wash?
Peak Mart. Peak Mart.
PEAK
Yes.
MART.
Yes.
2 words or one?
2.
2 words. Car wash. And where is that?
It's on El Capitan and Flamingo.
So it's in Las Vegas. All right. Very good. I'm glad you're working and staying clean. That's the most important thing, and taking good care of your daughter.
Just for the record, Your Honor, we're serving these documents on Mr. Glennon at 6069 South Fort Apache Road, number 100.
Yes.
Okay. So
You want
I'll
it by
serve
mail, right? You prefer by mail?
Yes, the problem is if you do it by email, then I've got, I have a day job, and I have my day job email, and I have people working on those, and then I have my email for this job.
Right.
And I want to make sure I get it, and
Well, I'll just
probably
mail it to
consider
him,
party
that's
be
fine.
fine.
She'll mail everything.
And
There's probably a misunderstanding about accepting email.
and
If that's more of a trigger for you, she'll mail them, regular mail.
that's fair.
Does he want the proposed order mailed to him too? Emailed both? I can do whatever. I just
We
want
can
You want both, email and mail?
Yeah, we can review for.
As long as he gets mail, he's okay with email too.
Okay, perfect. I will do both.
Yes, please. Yes, please.
Discovery hearing, please vacate that. Thank you.
All right. Thank you guys for your appearances.
Thank you, Your Honor.
Thanks for your work on the case.